In our continuing coverage of the Trump Georgia indictment, as we've previously discussed, Mark Meadows has sought to have his case removed to federal court on the basis that what he did was part and parcel of his federal responsibilities, and thus, under relevant federal law, should be heard in a federal rather than state court. And of course, we expect Donald Trump himself to also seek this maneuver. Donald Trump had sought this maneuver with respect to the New York stuff that was bought by Bragg, but New York stuff was with respect to his company, not with respect to Donald Trump, so the motion was denied. With respect to what's going on in Georgia, much more of it relates directly to what he did or didn't do as while he was president. And so it relates much more closely to his official function. So there's this whole dispute about whether or not either of these cases will get heard by a federal court. This article seems to think the answer is no. It also seems to think that that's bad. So let's read a little bit more about this article and the issues as we try to decide whether the Georgia case currently being heard in Fulton County will instead be heard by a federal court with a wider jury pool. Let's get started with this. The first skirmish of the Georgia prosecution erupted on Wednesday, August the 16th, when former White House Chief of Staff Mark Meadows asked for his case to be removed to federal court, to use the proper nomenclature. Former President Trump likely will follow suit soon, not for least reasons that he tried this exact maneuver with respect to the New York State stuff that had been brought by Bragg, but his claims in Georgia are a lot stronger. Both hope that by shifting to federal court, they will get a more favorable jury pool, pulling from outside the metro Atlanta, because one of the reasons that you might want to do this as a practical matter is that the nature of the jury pools is different, right? So if you're in state court, if you're in Marion County, your jury pool is Marion County. If you're in federal court, the federal district is a much wider swath of state, much more people, much broader pool, and also perhaps much more favorable odds of getting Trump people because you're outside of metro Atlanta. So the odds of finding a jury pool more favorable to the president or anyone else charged is a lot better in a federal system. But both could argue there's a bigger principle at stake. Imagine if every new time a president took office, an elected state prosecutor of the other party drummed up a grand jury indictment alleging campaign finance or financial wrongdoing. Yep, right, because once the seal is broken, it's broken for everybody. With 50 states and countless counties and municipalities, it's easier to imagine the churning chaos that could follow. Far better, therefore, to channel all such cases into federal court, where lifetime judicial appointments, sensitive to national interest, would manage those cases in an orderly way. So one of the things we're concerned about, and one of the reasons this federal law exists in the first place, is because we're concerned that state-level authorities or local-level authorities or some local prosecutor somewhere interested in potentially getting their name in the paper might drum up a charge against a federal official, potentially for campaign finance violations, for example, just to be able to get their name in. And we're like, this local prosecutor somewhere is interfering in the federal function, interfering in a federal campaign, and we don't want to do that. So one of the reasons we would want to transfer this to federal court is to prevent that from happening by taking away that home field advantage, and also by allowing the federal courts to throw out the indictment if it's based on improper reasons. So that's one of the reasons the federal statute exists, and one of the reasons it might be a good thing. It is a powerful argument, especially for Trump, which, yes, because many of the things that happened that were alleged against Trump happened while he was in office, and Trump, as head of the executive branch, has more protection, obviously, than any other member of the executive branch, because he is the executive branch unto himself. So he has the defenses anyone would have in the entire executive branch, right? Other members of the executive branch have pieces of defenses, but the president, because he's president, has all the defenses. So obviously the role of the president is much more central to the constitutional system than any other particular federal role. So there's that issue. But until Congress changes the rules for moving cases from state to federal court, it offers no lawful ground for changing courthouses. I'm not sure about that. It seems like it does, but okay. Trump's case should, as a matter of law, stay in Fulton County, even might be better for the nation and federal court to handle it. So this author thinks that the law says this should be in Fulton County. I am less convinced of that proposition. The relevant federal law basically seems to say if it happened as a result of it happening within the scope of your office, which trying to determine that gets a little bit trickier. But if you're the president, the scope of your office gets immense, right? So, yeah, that I'm not so sure about this. So, whether Mark Meadows can remove it to federal court, although I think probably yes, I think Donald Trump's argument is even better. So, I'd actually be slightly surprised, or actually more than slightly surprised, if Donald Trump's case doesn't get transferred to federal court. I'd be very interested to see that judge's rationale on that, because so much of this happened as a result of while Trump was in office, and he has colorable claims that some of it was protected by his office. So, yeah, I think federal court might be the better option based on the relevant law. Understanding this entire situation would require digging a bit into an obscure law, and in this context, it is fairly obscure because criminal removal is very rare. Like civil removal to federal court on a civil case dealing with diversity of jurisdiction, not exactly uncommon. Removal of a criminal case to federal court, yeah, I'm not sure when the last time that happened was, to be honest, because of how rare it is. So it is relatively obscure. Normally, of course, each judicial system does its own thing. Judges on both sides keep out of each other's way. Yeah, and there's all kinds of federal preemption doctrines and also abstention doctrines, right? So when you're dealing with the federal courts and how they can interact with states, there's all kinds of stuff dealing with preemption, which is the idea that the federal government obviously has the ability to have its law imposed on the states, but also the exact opposite of preemption doctrine called abstention doctrine. We're abstaining, right? So even where the federal courts can get involved, they often won't if it involves a state issue because they have respect for state level sovereignties. So yeah, all those kinds of things, right? So yeah, normally both systems kind of try to stay out of their own way, which is a good thing because they're separate systems. Congress, of course, for its part, has identified a carefully determined class of cases that can be moved to federal court as soon as cases are filed, which is called removal. This is the kind of removal that's at stake because this involves a federal officer. So the idea is that the crimes occurred as part and parcel of your role in your federal official role, which if you're doing things within the scope of your role as a federal official, they can't be a violation of state law, because if it were a violation of state law, that would mean a state could nullify the federal government. If a state could determine that something that is a federal power is illegal, then that would prevent the federal government from acting. And that would be really, really dumb. So in order to prevent that, the federal courts can step in and say, like, yeah, state, you can't make illegal what the federal government makes legal. You have to stay out of the federal government's way. So if it happened within the scope of their office, you can't make it illegal because that would be really dumb. Since 1815, Congress has allowed certain federal officers to remove cases against them to state court. The first such removal statute was enacted against the backdrop of state hostility to federal tax collection. So, perhaps unsurprisingly, this all started, at least in part, with money, because money is money. And people are like, we don't really like the federal government taking our money. We're going to make it illegal for the federal government to take our money. And so, yeah, that makes sense. The nullification crisis of the 1830s and the Civil War gave Congress fresh cause to enact measures in the teeth of roller state anger. So one of the things that states were trying to do in this time period was trying to nullify state laws. A lot of states were saying, okay, federal government, your laws don't apply in our state. And the federal government's like, yes, they do. So to the extent federal law applies and states can't interfere. They don't have to help. They don't have to assist, but they can't interfere. So if the tax man from the federal government wants to come around, and start collecting taxes, the state doesn't have to do anything to assist them, but they also can't do anything to interfere with them. So that is the line of demarcation that we have drawn. The present version of the law dates to 1948. It covers, notably, all federal officers for any act under color of office. So if you did it claiming it was within your official role, right? If you did it under color of office, then that's a federal crime. And incidentally, the federal government has already charged Donald Trump with exactly this as a result of January 6th. In the January 6th case, Jack Smith, the federal attorney, has charged Donald Trump with, among other things, acting in violation of color of office, 18 USC 241. He has claimed that some of the things that he did were under color of title. So the federal government has already claimed that some of the things that were relating to the January 6th stuff were relating to color of title. And some of those things are also within the Georgia indictment on the state level. So the idea that there is a color of title argument that is possible seems very possible because the federal government has already said there is. So Donald Trump may be able to somewhat ironically use the indictment against him from Jack Smith in DC relating to the January 6th stuff as a basis for saying the Georgia stuff should be transferred to federal court. So he might be able to use one indictment against him as a basis for potentially more favorable action in another indictment against him, which is kind of funny, right? The act of one sovereign gives a basis for action against a different sovereign. But, that's in the nature of federalism. When the federal government acts, it may overrule state interest. Despite the qualification language, the Supreme Court has read the language sweepingly in civil cases to capture any state case where an official defendant is sued based solely on official duties, even if they have nothing to do with criminal law or taxation. So if this were a civil case, we've already dealt with this, but this is criminal in its nature. And the courts have, at least historically, looked at this a little bit differently. Were this the relevant test in the criminal case, Meadows and Trump, of course, would have a powerful argument to take at the federal court. But the Supreme Court, with respect to criminal cases, has carved out a narrower ground for removal in criminal cases since states have a sovereign interest in the enforcement of their own state criminal laws. The Supreme Court, with respect to criminal cases, has insisted that removal is allowable only where the defendant has a colorable defense under federal law. So in civil cases, they're a little bit more free to transfer, but in criminal cases, they want something where there is a greater tie to the federal action because states have a sovereign interest in the enforcement of their own criminal laws. So the only way that you can remove it is if there's a colorable defense. So the idea is that you have an arguable defense to your actions, which in Trump's case, I would think would apply, and even in Meadows' case, I think would apply, because some of the stuff may very well relate to their federal role. And it only has to be a colorable defense, not necessarily a successful one. So do they have any argument that what they did was in furtherance of their federal function? I think the answer is probably yes. So I think the odds of removal seem to favor this, but this article seems to disagree. So very interesting. The leading case on point on such issues, which is called Mesa versus California, written by Sandra Day O'Connor, who is also herself a former state legislator, so that also may speak to her philosophy. Explaining the need for a specific federal defense, Justice O'Connor offered a constitutional rationale. Article 3 of the Constitution defines a fixed and limited number of cases that can be funneled from state court to federal court. This includes cases turning on federal law. Unless the court insisted on a colorable federal defense, she explained, defendants might remove cases that did not meaningfully turn on questions of federal law. There would be, said O'Connor, serious doubts about the constitutionality of federal officer removal, which, fair enough, right? It only relates to whether or not you actually have a defense that exists as a result of your federal function. So, yeah. The state-level prosecutor has drafted an indictment that makes it exceedingly hard for Trump to meet the standard, which I'm not sure that I agree with. And they argue that Meadows is a closer case, but I'm not sure I agree with that either. Although Meadows' actions are more exclusively tied to his actions within his federal role, Trump's actions, although maybe less tied to his federal role, Trump is the president of the United States. And so therefore gets special protection because he is the entirety of the executive wrapped up into itself. So yeah. For one thing, the relative acts alleged in the complaint pick out actions Trump took place on September 17th, 2021, still importuning, which is one of their favorite words, it seems, Georgia's Secretary of State to decertify the action. There's no plausible federal defense for these actions, which occurred at a time when we all agree Biden was in office, which maybe as to those particular acts, possibly, right? So some of these acts possibly occurred outside the time that Trump was president, but some of the acts occurred while he was president, And so the issue is whether he has a colorable defense. And if he has a colorable defense to some of the acts and some of the acts disappear, that necessarily weakens the overall case. So I don't think it's necessarily enough that some of the acts occurred outside that time period. Because since so many acts occurred within the time period, and he would have defenses as to those would strike out those portions of the indictment, and the indictment would necessarily be weaker, even if legally sufficient, which is also questionable. So, yeah, it's unclear whether or not that works. Even the famous January 2nd, 2021 phone call by Trump to Georgia Secretary of State has no plausible federal defense. I'm not sure that's true either. Trump may try to characterize the call as presidential enforcement of criminal law against election fraud, but that's not a colorable claim, which I'm not sure that's true either. After all, it's the Justice Department's role, not the White House, is to investigate potential federal crimes. See, this is where you kind of lose the plot a little bit, right? Yes, it is the Justice Department's role, but the Justice Department exists as a fraction of the president's power, right? All executive power is embodied within the president of the United States. It's Article 2, Section 1, right? So the Justice Department is the president, and the president is the Justice Department. So yes, it's the Justice Department's role to investigate federal crimes, but the president controls the Justice Department. He controls the Attorney General. He controls the department. It is him. So yes, there is a role. It isn't necessarily the White House, by the way, right? If we're thinking about the White House as an institution, the question isn't, does the White House have a role? In which the answer might very well be no. The White House doesn't have a role. The question is, does the president have a role? In which case the answer probably is almost certainly yes, or at least there's a colorable argument. The answer is yes. So I think there is a colorable claim that when Trump made the call, he was furthering the official function of the Department of Justice because he is the Department of Justice. As the former Attorney General told the Select Committee, it had done and had not seen evidence of fraud that would affect the outcome of the election, which is the Department of Justice's view. But of course, then again, the Department of Justice is agents for the president, because that's the nature of unitary executive theory. Because the president is the executive branch, as Article 2, Section 1 says he is, the executive branch is the president, that the advice of the Attorney General, the advice of the Department of Justice, is advice from the agents. But obviously, as the principal, the president might have a different view. That whole chain of command thing, right? Because he's above them in the chain of command, it's like, your views are interesting and all, but I have a different view of the thing. And so there's at least a colorable argument that he was acting in furtherance of his official function. In any event, Trump's own questions to the Georgia Secretary of State plainly give lie to any claim to be acting in presidential capacity, rather as a disgruntled candidate. No prosecutor imaginable says, I just want to find 11,780 votes, which is one more than the margin of defeat because we won the state. I mean, okay, the question isn't whether or not, I don't think Trump needs necessarily he needs a colorable claim as every single element or every single charge. I don't think that's the standard. I don't think it's not that he needs a colorable defense to, like, he needs to be able to defend every single thing, right? He just needs to be able to attack the things. Because if he has a defense to some of the things, then if those things get eroded, then the nature of the complaint against him gets weaker, right? That's sort of the idea, at least theoretically, right? The idea theoretically from George's point of view would be that each of these supporting acts, all 150 of them or however many it was, like, each of them are pillars that uphold the indictment, right? They're all sort of foundational pillars. And knocking out some of those pillars makes the foundation weaker. And if you knock out enough of them, if you knock out enough pillars, the building itself might crumble. So I'm not sure he necessarily needs a defense as to every single act. He just needs a colorable defense to the acts that raise a colorable defense as to the charge as a whole. Because basically the defense at that point becomes, you don't have enough pillars, right? You have some things here that are scattered around, but nothing enough to hold up the entire foundation. So I think he just needs a colorable defense that basically relates to weakening the overall case against him, not necessarily knocking out outright. So I'm not sure this is the right way to look at it. However Meadows and others are treated then, Trump cannot remove his criminal case from Georgia to court under existing law. I'm not sure that's true. I'm not sure that's true. I mean, there's certainly legal scholars who disagree with me, and I will take note of that. That if you go read the press, there are a lot of legal scholars out there who seem to think that the ability of Trump to remove this is weaker. But I seem to think, at least for me, I think it's more plausible. I would be a little bit surprised if the judge denies the removal on this case, and if he does, or she does, as the case may be, because I'm not sure which judge would review this. But if the judge who reviews this denies it, I'll be very interested to read that rationale, because it'd be interesting to see whether or not I agree with it. And then, of course, that decision itself is appealable, one would presume, because that is a dispositional issue, right? If whether or not it's heard in federal case would have to be reviewable on interlocutory appeal, because it goes to an issue that could not be cured down the line. Right. So as a standard matter, you don't have the ability to appeal like every decision that happens unless the nature of it is uncurable. And I think this might fall into that uncurable category. So yeah, so we'll see what the judge says, and then I suppose either side will appeal, and then we'll see how that goes. And then we'll be maybe off to the Supreme Court, and that could be super fun. So we'll see how that all goes. If he were to take his case up to the Supreme Court, the current justices would be forced not just to alter the meaning of a 75-year-old law, which I'm not sure that's true, but to confront Justice O'Connor's deeply rooted and powerful constitutional argument, which I'm not sure that's true either. I'm not sure they have to overrule the precedent or disagree with O'Connor. They just think the standard is met. Doing this would demand an enormous and very plainly partisan lift. I'm not sure that's true either. None of this, however, means that those concerned with democracy and the rule of law should rest easy. Just as in 1815, 1830, and 1865, there's powerful federal policy interest in centralizing prosecutions against national candidates. It is not implausible to think that Congress should enact a statute expanding national candidate removal to avoid the evil of a rogue prosecutor. And perhaps it should do so. Such a measure might appeal to both sides right now, albeit for different reasons. But until that happens, what happens in Fulton County has to stay in Fulton County, at least where Trump is concerned, although I'm not sure that that's true. So there is a difference of legal opinion at this time as to the probabilities of Trump's being successful. So this article seems to think it's essentially a foregone conclusion that Trump will lose this argument, and I think that the odds favor Trump. So we have a difference of opinion on legal interpretation. So we'll see which way it goes, I guess. Thus, that brings us to the end of this article for the moment, discussing the issues about whether or not Trump will be able to take his case from state court to federal court. This article seems to think the answer is no. They seem to think the law does not favor Trump's ability to take this case to federal court. I am much less confident in that conclusion. I think the odds favor Trump being able to take this to federal court. A lot of this stuff seems to be related to his role as president. A lot of the charges occurred during the time he was president and relate to things that might be at least colorably within his role. Like, even if ultimately they aren't within his role, even if ultimately you conclude they're not, right? It isn't an issue about whether or not they are. It's an issue about whether there's a colorable defense. Is it at least arguable? Is it non-frivolous? Maybe might be a way to look at it. Is it non-frivolous to say that Trump has a defense to at least some of this stuff, because some of this stuff might relate to his official job role, taking particular note that his official job role is President of the United States, which is the executive branch, which goes a long way. The job role of president goes pretty far. So does some of this relate to his official job function? Probably yes. So we will see as this case progresses whether or not Trump is able to remove this federal court, and I would imagine either way, what the federal court decides, we're off to appeal, and possibly the U.S. Supreme Court before this ever gets started. So fun times ahead for the law, to be sure, and that for the moment brings us into discussion of this story.